Chapter 11 is about the law of torts. A tort is defined as an injury to another's person or property. They talk about tort cases. They're commonly referred to as personal injury cases. Although a tort case may involve harm solely to property, the primary goal of the tort law is to compensate innocent persons who are injured or whose property is injured as a result of another's conduct. The next thing that I found important on Chapter 11 was discourages private retaliation by injured persons and their friends. Damages available in the tort cases: the victim may sue the wrongdoer, known as the tortfeasor, and has the potential to recover from among 3 types of damages: compensatory, nominal, and punitive. Compensatory damages is defined as is designed to make the victim whole again, to put them in the position that he or she would have been if the tort would have never taken place. So it's designed to help with medical bills, lost wages, any property repairs that may occur, any compensation for pain and suffering. The interesting thing about that is knowing that attorney fees are not considered part of the compensation. They're usually taken out of the pay that they actually are awarded. So say they're awarded $20,000 for compensation, the lawyer may take $2,000 of that, for example, for their lawyer fees. So they're left with $18,000 to cover all of their losses. So I thought that was really interesting. Nominal damages: sometimes the plaintiff is unable to prove damages that would necessitate compensation. The sum of the awards is minuscule, but the recovery of the nominal damages may be important because it does allow the plaintiff to seek punitive damages. Punitive damages is when the act of the tortfeasor is flagrant, unconscionable, or so the court may award the victim the punitive damages, and is designed to punish the tortfeasor for willfully engaging in extremely harmful conduct, but also to deter others from engaging in similar conduct. So it's useful in deterring manufacturers from making unsafe products. That was the main thing that they were discussing when it came to the punitive damages. Intentional tort: a civil wrong that involves taking some purposeful action that the defendant knew or should have known would harm the person, property, or economic interest of the plaintiff. Negligent tort: a civil wrong that involves failure to meet the standard of care a reasonable person would meet, and because of that failure, harm to another is the result. Strict liability tort: a civil wrong that involves taking action that is so inherently dangerous under the circumstance of its performance that no amount of due care can make it safe. Assault: intentional placing of a person in fear of apprehension of an immediate offensive bodily contact. Battery: intentional, unwanted, and offensive bodily contact. Defamation is also considered intentional. Libel: publication of a defamatory statement in permanent form. Slander: spoken defamatory statement. Absolute privilege: the right to make any statement, true or false, about someone and not be held liable of defamation. Conditional privilege is the right to make a false statement about someone and not be held liable for defamation, provided the statement was made without malice. Public disclosure of private facts: a privacy tort that consists of unwarranted disclosure of a private fact about a person. They talked about false light, appropriation, invasion of privacy, false imprisonment, intentional infliction of emotional distress, I had never heard of that last one. It says intentionally engaging in outrageous conduct that is likely to cause extreme emotional pain to the person toward whom the conduct is directed. Trespass to real property, intentionally entering the land of another or causing an object to be placed on the land of another without the landowner's permission. Trespass to another trespass they were talking about, intentionally exercising dominion and control over another's personal property. I haven't dealt with that in personally, but my mom has. We have land down in Virginia. My mom actually lives there, and she has 2 separate properties. And the one property that she doesn't actually live on, she just has animals over there. And she did have a canning house, which it's a building that you store your canned goods in, and you can cure meat in there and different things. Someone actually decided to take bolt cutters and cut off the very heavy chain and the lock that were on the gate that takes you down the road into the property, and broke the door off the canning house and actually stole all the food that was in there. The best thing that I can say about that is I hope that they were really in need for that, to go to all that trouble to break in there. It's pretty upsetting to know that someone has no regard for someone else's property. So that's something that I unfortunately have personal connection to on that aspect. And not only one chain, but I think we're at maybe 5 now. Someone just keeps intentionally cutting these chains off and going in there. I don't know what they're expecting to achieve by doing that, but nothing's happening, so they just keep doing it. They also explained res ipsa liquider. I'm not really sure if I'm pronouncing that correctly, but they said that it means the thing speaks for itself. So the plaintiff uses this doctrine to allow the judge or jury to infer that the defendant's negligence was the cause of the plaintiff's harm when there is no direct evidence of the defendant's lack of due care. They also talked about contributory negligence, a defense to negligence that consists of providing that the plaintiff did not exercise the ordinary degree of care to protect against an unreasonable risk of harm, and that as failure contributed to causing the plaintiff's harm. Comparative negligence, assumption of the risk. So all of these things, they were very detailed and defining each of them to let you know ultimately what the different laws are as far as where you would find negligence or find someone else at fault. Chapter 12 is about product and service liability, and it talks about the privity limitation, which privity means that one is a party to a contract. Talked about negligent failure to warn. The negligence-based product liability actions result from a failure toward or inadequate warning, the design and the sale of defectively designed products. So making sure that that doesn't occur, and when it does occur, to have that law set up. Defenses to a negligence statute of limitations. Talked about a statute that bars actions arising more than a specified number of years after the cause of the action arises. Statute of repose, a statute that bars actions arising more than a specified number of years after the product was purchased. State-of-the-art defense, a product liability defense based on adherence to existing technology feasible standards at the time the product was manufactured. Talked about warranty, a guarantee or binding promise that goods or products meet certain standards of performance. As far as warranties go, like I recall whenever we bought our refrigerator It was a very expensive refrigerator that my husband insisted that we needed. It was about $4,000, and it came with a 2-year warranty by the manufacturer, and then the place that we purchased it from was trying to offer us an additional 3-year warranty, so that way you have 5 years total. And of course that's an additional cost as well. So warranties on products like that, definitely, you got to weigh out the pros and the cons. If something happens after that 2-year mark, it might happen the very next day. I know it's happened. I know people who have had that happen to them. And the warranty has expired with the manufacturer. If you pick up that extra warranty, then it's still going to be covered. But then you have to remember that warranty only covers certain things. It's not going to cover everything. So then you really got to stop and think, okay, am I going to pay all the extra money and then keep my fingers crossed that it's actually going to cover it? And that's up to the consumer. Each person has to decide that for themselves. Talked about the disclaimer, disavowal of liability for breach of warranty by the manufacturer or seller of a good in advance of the sale of the good. Market share theory, a theory of recovery in liability cases according to which damages are apportioned among all the manufacturers of a product based on their market share at the time the plaintiff's cause of action arose. Malpractice suits, service liability suits brought against professionals, usually based on a theory of negligence, breach of contract, or fraud. And then the last thing that they mentioned was Ultramar's doctrine, which rulemaking accountants liable only to those in a privity of contract relationship with the accountant. So some of these things in Chapter 11 and Chapter 12 I was able to relate to, as I did state, and a lot of it covered things that I wasn't aware of. So it was a pretty interesting read. Hope you enjoyed it.